All right, let's move right into it, ladies and gentlemen. So you get here from me this morning for about half an hour. Enforcement is one of those things in our jobs that sucks, but we have to do it, right? We need to keep people in compliance, and that's what we're looking for, is compliance. Do I really care how they get in compliance? Probably not, right? And we have various methods to get people into compliance. By cheating. Yes, no. That's how they get out of compliance. The one thing that I always tell people when I'm doing enforcement is that I cannot provide you an economic benefit over your competitors. Right? I can't do something for somebody that I don't do for somebody else because it allows them to have an economic advantage over the competitors. If I tell this industry to put in a pretreatment system and the same industry over here with a different name doesn't put it in and doesn't have to treat their waste, then they get an economic advantage because they get to keep that money that this industry used to put a treatment system in. Right? Whether that's a couple $1 million or whatever it is, it's still an economic advantage. It gives them an advantage over somebody else. You need to follow your escalation steps. Every one of us that has an approved program should have an enforcement response plan. Okay, and in that enforcement response plan, it should tell you the steps to take. And it should tell you who should take those steps. Okay? As the pretreatment director at South Valley, I've been given the authority to do all enforcement. I don't have to go to the general manager like some facilities do. The enforcement falls solely on my shoulders, but there's still steps above me that have to go to the general manager. If I have to go to judicial arrangements, I have to go to the lawyer and I have to go to the general manager to get his approval to say, hey, we need to take these folks to court because of this. If I have an industry that says, oh, Spencer's being so mean to me, he's picking on me, they have the right to appeal to the general manager my decision. If they don't like the general manager's general manager's decision, they have the right to appeal to our 5-member board. Okay? But you need to follow the steps of enforcement. You have to escalate your enforcement as necessary. One of the things that I do, especially for like our smaller industries, is we will do 3 NOVs. On the 3rd NOV, it's a show cause order. Because my enforcement response plan says if they're late on a report, I should call them. If they're late 30 days, they get an NOV. But if it's an SIU, at 30 days, it's SNC. At 31 days, actually. Because now they're more than 30 days late. Okay? But you need to follow that. That's one of the first things they're going to ask you when the state comes in or the EPA comes in is, did you follow your enforcement response plan? Because of the fact that if you didn't follow the right procedural steps, you're going to get your case thrown out of court if you go to court. You're going to have lawyers fighting you because you skipped a step. Okay? So follow your enforcement response plan, no matter how it's set up. If you think it is crazy the way it's set up because your predecessor set it up, then go through the effort to change it and put in the steps that you need to. Go through public comment. Because once you get up to NOVs with fines, that's called a taking. You're taking money from them. Which means if you haven't followed the proper steps, you're violating their rights under the Constitution. Okay? That's one of the things that Kurt McCormick, who we gave the award to last night, one of his biggest things is if you are going to fine someone, you have to have the public comment period before you adopt that ordinance. Because if you're going to take even $1 from someone, if you haven't done the public comment period, that doesn't mean you got comments on it. It means you went through the effort to put it out for 30 days for people to be allowed to make comment on it. Nor does it mean that if they make comments on it, that those comments are valid or you're going to take them under consideration. It just means that you went through the effort to put it out there for the public to see it and to be able to say, Okay, or no, this is a bunch of garbage, right? But if we take $1 without doing the public comment, then we end up we violate their civil rights, or not their civil rights, but their constitutional rights. So make sure you public notice. Okay, our enforcement response plan for a lot of things just has a phone call. You know, it says call. I can have one of my staff do it, I can do it myself, but you call, you say, hey, your report's late, I need this signed, I need this in, I need it here today, hand deliver it, whatever else. Not that hard. The one thing on the phone calls, on any phone call that I suggest you do, keep notes. Because you'll always have somebody call up, ticked off, saying, you didn't tell me that. And if you can go back and say, on June 14th of 2019, we discussed this. Me and so-and-so and so-and-so, all of us discussed it over the phone because you had two people in the room with you, and it sparks people's memories and it shuts them down. If you have dates and times to it, it shuts them down. If you just go, well, we talked about this last year, they're going to go, the hell we did, right? Because there's no recollection of it. When you can put a date and time to it, it shuts people down. So keep notes on your phone calls. Notice of violations are a formal enforcement action. Okay? When you sign or have the general manager sign or whoever is your authority to sign NOVs at your facility, that is a formal enforcement action. Because you are sending written notice to them saying, you're in trouble, come to the principal's office, right? Make sure you send it certified or hand deliver it. And if you hand deliver it, have some form. I know Central Weber has a form that when they hand deliver their permits or when they hand deliver their NOVs, they have somebody at the front desk sign for it so they can say, I delivered it to so-and-so on this date. And she signed for it, or he signed for it. But make sure you have a return receipt of some sort so that if they come back and they have a time limit to do something in those days, whether it's a response or whether it's something else, make sure that they have a signature on there so you can say it was delivered to your facility on this day. Okay? In your NOV, you need to make sure you define what parameter was violated. Whether that was a sampling permit violation, you know, because they exceeded a pollutant level, whether it was they missed a deadline on their compliance schedule, whatever it is, make sure you note in the NOV what it is. So that they are aware. They're not just getting this letter saying, oh, you did a bad thing, and not tell them what that bad thing is. Then we go to an NOV with a fine. Because administrative show cause, you know, it disrupts a lot of people because you got to bring people in. But we'll go to a fine. Now, it doesn't have to be a big fine. Sometimes it's, you know, $500. But it's $500 of a taking. That $500 comes out of their pocket. That $500 makes their eyes open a little bit and realize that maybe, just maybe, it was cheaper to clean their interceptor, or it was cheaper to send in their permit, you know, send in their permit when it was due, or whatever else we're doing. Usually this is on repeat violators. We have Jiffy Lubes. All our Jiffy Lubes are owned by the same parent corporation in Utah. And it could be because they're the same parent corporation that this Jiffy Lube violated, this Jiffy Lube violated. We had 4 of them from the same parent corporation in the same, I think we did them in 2 months. We sampled all of them and they all violated at the same time because they decided that it was costing them too much to pump their oil water separators. So we brought them in and fined them because they're all run under the same manager. We'll do an NOV with a fine before we go to administrative show cause. Okay? Follow your enforcement response plan. When you have an administrative show cause order, you're going to send them a formal letter saying you are ordered to come to a meeting. They are now being called to the principal's office. Okay? It disrupts a lot of people's lives because they have to stop what they're doing on that day. They have to come to that meeting and they have to show cause why they shouldn't be fined anymore. Because if they've already received an NOV with a fine, now you're going to escalate and that fine is going to go up. Because if we get to administrative show cause, now they've had at least 3 violations at the same location. And we've given them 30 days in between each one to try to clean it up. Okay? Issue your fines at this time. Have it ready to say, hey, here's your $1,000 fine, or here's your $10,000 fine, or here's your $1.5 million fine. We had one of those years ago. After they picked their jaws up off the table, they said, we're not paying this, we're calling our lawyer. Call your lawyer. Lawyers are welcome, and we put that in our show cause order. Lawyers are welcome to attend the show cause. For the simple fact that I don't want an industry to go back and say, this is what they said. I would rather the lawyer hear it right from my mouth of what we said. And that goes along with keeping notes. Keep record of what was discussed in that meeting. Keep record of who was in attendance and what was said. And share those notes. Share them with the lawyers, share them with the industry, because it gives them a chance to come back and say, that's not what I said, please correct this. Then we correct the notes, we resend it out. These are stressful times. Not only for you as the regulator, but also for the industry, because that manager may not be the owner of the company, and he's thinking, I just got fined, my job's on the line. Okay? The thing I like to do, and I tell my people this all the time, is be business professional. Okay? You may think this industry is the biggest pain in your neck because they're the #1 violator in your area, whatever else, but you be business professional. You don't say anything untowards, you don't say anything out of character, you just say, this is the issue, this is the findings, this is the fine, how are we going to resolve this? And you work together with the industry, come up with a consent order, come up with a schedule to put in new equipment, whatever else, and you give them the fine. If you do it right, they're not going to like paying the fine, but hopefully they understand why they deserve the fine, and they'll walk out maybe not being your friend, but at least they'll respect you because you handled it professionally. But if you get ticked off and you're yelling across the table at each other, how's that productive? Okay. Going back to our $1.5 million fine, they had lawyers there. My predecessor, as soon as the lawyers would sit down, he'd stand up, he'd leave the room. He's like, I ain't talking to lawyers, because the lawyers kept trying to force federal regulations on us. Our ordinance said that pH violations were instantaneous, and we had like 95 of them. We had a couple other issues. They wanted to put in a larger system. They wanted to put in more production systems. Their treatment system was undersized. There was no way it was going to be able to handle. It wasn't handling the waste that was being produced then. It wasn't going to handle the waste of 3 more production lines, nor of a different type of product that they were fixing to make, which was going to be heavier in pollutant levels. So he kept getting up and leaving. Finally got to the point that, because we told him, we were like, you need a new treatment system. It finally got to the point where plans showed up for a new treatment system. Because we put them in SNC, they were in the paper, they got a black eye, their stocks kind of dropped, and they put in a new system, did a nice spin on it, had a nice newspaper article about how they were going green and they were saving the treatment plant, because this same industry, years previously, had to replace a sewer line because their pH was so out of whack, it ate out the bottom of the sewer line for about a mile. Okay? We got a $15 million treatment plant by levying a $1.5 million fine, and by being professional about the whole thing. And maybe, some of you are probably thinking standing up, walking out of the room isn't very professional. But it's more professional than yelling across the table at people that you think are morons. Because that's what my predecessor thought. He thought these lawyers are idiots. They don't know the law. They don't know environmental law. They know law, but they don't know environmental law. They don't know the Clean Water Act. So it's easier to do that. Just like in a relationship, it's easier to walk away than to fight and cause more issues down the road. That industry does all it can now to stay in compliance. It still has its issues, you know, but they do what they can to try to stay in compliance. If you go to judicial relief, you have to involve your lawyer, which means you have to share with your lawyer everything, all your notes from phone calls, all your NOVs, all your files on your interactions with this industry, so that they can be prepared to take it to court. Now, judicial relief is not criminal. We're not trying to go and throw them in jail. We're just trying to get money back for losses of the POTW. Okay, so whether that's a sewer line, whether that's, you know, you had fines from your regulatory agency because you violated your permit because of something they discharged to you, that's all judicial relief is. You're trying to recoup that money. And you're trying to get them to stop whatever they're doing that's causing the problems. Criminal charges are totally different, because then you need to get the law involved, you get CID involved, but that's more for something that's going to cause harm to life or cause major issues, like they're dumping hazardous waste. You know, they're doing something that is causing, you know, they're dumping something that's mixing with something else down the line from another industry, causing gases to come up in somebody's home, suffocating people, whatever it is. That's when people's lives are on the line. Okay? Unorthodox methods of resolution, that industry replaced a mile of sewer line. It was proved to them that they were the cause of it, and they replaced that whole line. Cost them quite a bit of money. And there's still a couple of their general managers, they rotate general managers about every 4 years. And a couple of their general managers have rotated back since that was replaced, and they still kind of complain, yeah, I own that section of sewer pipe, you know. But you can make them do remediation of some sort too. Okay, they can go and they can make a wetlands for you, or they can do whatever, as long as you're putting the burden on them to do something good for the money that they caused everybody else. If it comes to it, you know, I sever their sewer service. Tell them, you're done. And don't think that doesn't work. Because when the NSA came to Utah, we had an engineer who was taller than me, he was about 6'8", just ticked. And we're like, we called it an approval letter at the time. We're like, we need to issue an approval letter. And he's like, this project has been approved. What are you saying? We're approved. The government has approved it. We're done with this. He was livid. And we looked at him, and DeLon says, well, you don't have to tie to the sewer. And all the sewer district whose sewer it was in, the general manager there, his jaw dropped because he'd already cashed a check of $1 million or whatever the impact fees were. Everybody else is just like, and we're like, it's a right to, you know, it's not a right to tie to the sewer, it's a privilege. So you can build your own treatment plant. He shut up, sat down, meeting ended. I came back to the office, found in the Clean Water Act where it says all federal institutions will comply with local regulations, sent that off to Maryland, got a letter back on NSA letterhead, which not everybody gets that. It's a little concerning at times. Said, when would you like to meet and what do you need to see? It took us about 6 months to get in there and a couple rectal exams and fingerprints. It was terrible, but we got in there and we saw what we needed to see. Because we were business professional, we used the regulations to our advantage, and we educated those individuals to be able to get what we needed. Okay? Significant noncompliance. You have a TRC that if you exceed 33% of your pollutant levels or of your sampling events, you have to put them in SNC. That's for a rolling 6-month average. Okay? And so what I do, and this is where I tell you guys to talk with people here at the conference, because I stole this. Well, I shouldn't say I stole. They shared this with me. Okay? This is an Excel file that I can put in the results. And this is in pounds per day because I use it for our industry. This charges about 800,000 gallons per day, but we give them a 2,350 pounds per day of BOD and TSS. Okay, so I can put the pollutant levels in here, the pound analysis in here, And it will tell me what the daily limit is based off the TRC, so their TRC is 3290, and it will tell me if they exceed that or not. Now, if they exceed more than 33% of however many samples I have, it'll total up the samples down here, whether it's 6, it's 12, it's 8, whatever it is. If that exceeds 33% of their samples, then they're in SNC. Okay? And you got to do that. So this is from January 1900, by the way, because I haven't put a date in there. This is from October 2020 to March 2021. And the next one will go from March 2021, or from January to June. So now we're going from October to March, now we're going January to June. And so this is how it rolls over. The next one's from April to September. And so it takes the 3 previous ones before it, and then it kicks it over and keeps going. But you have to do that rolling average. And it's fairly easy to do it on Excel, but you have to remember to do it. The other things get you an SNC is if you're 31 days past when you're supposed to submit your reports. So if you want them quarterly and they're 30 days past that, or if you get them annually, however frequently you get them, if they're 30 days past the due date, or 31 days, they have 30 days, if they're 31 days past the due date, that's automatic SNC. Because obviously they haven't been listening to you, they know when it's due. Now, does that mean the first timer that you need to go bust their chops? No, it means you need to go educate them and say, look, you are an industry that is permitted in my sewer service area. If you do this again, you will be an SNC. I need this today. I will sit right here and wait for you to fill it out. Okay, because they don't know. Sometimes a new industry, you find a new industry, they've never been permitted before. They come to your area, they're like, well, we didn't do this in this other area. Well, you're not in this other area. Our regulations are slightly different. You're going to do it here, or you're not going to operate in this area. Okay? The other thing I do that I was given was a penalty form. And I put the two of them together. I got these from 2 different districts, but I put them together. This allows me to rank from 0 to 100 the history of noncompliance. How many times have they done this? If they're a repeat offender and they're brand new, their last 10 samples have all failed, that's 100%. Half their samples, 50%, however else you do it. You can put the degree of willfulness and or negligence. Are they willfully doing this? Did they tell you to stick it in your ear and they're not going to comply? That'd be 100%. Okay? Are they trying to comply? Are they putting forth their best foot forward to try to get back in compliance? Or are they thumbing their nose at you? Okay? Then you can put in the number of violations, and then it will spit out, based on the criteria down here, is the other thing. You put in how your emergency response plan says you rank your violations. Okay, so you can go A, B, C, or D. So then all you have to do is come up here and you say, you know, they're 50% of the time, they're okay, 50% of the time they're trying, 50% of the time they're trying to do a good faith effort, but they did a C violation, which means they violated our rules and regs, permit order, whatever else, and it was a significant excursion. A significant excursion, if they double their pollutant level discharge from what their permit says. If it's a 2.3 milligrams per liter, and they did a 4.6. That's double. That's a significant excursion because whatever treatment they were doing obviously wasn't working that day. So we're going to go on the C line and we're going to say they had 3 violations. There's your fine. $3,750. Now you can put in whatever. If I change it to 100, saying every one of their fines, every one of their things have been this way, it goes up. But have a format, have an SOP on how you're going to calculate these things. Because that's the other thing. When you end up in court, the judge is going to ask you, how do you calculate your permit? Or how do you calculate your fines? Because you don't want to just say, well, I pulled this number out of the air. They ticked me off, and so they owe me $10,000. Okay? Just because we can fine $10,000 a day, or $25,000 a day, or $50,000 a day, whatever your ordinance says, doesn't mean we should just pull that number out, okay? And say, this is what I'm going to fine them on, Your Honor, because I don't like them, they hurt my feelings, right? If you have a calculation form, you can say, this is why I did it, this is how I calculated it, this is the form right here, Your Honor.